So we did talk about the distinction between the Detention Act and you know the substantive anti-terror laws. So even though we are focusing upon anti-terror laws, substantive laws, but there are certain pattern which we see when at least the first detention law was brought in. So it was brought in first on 1st April 1951, and it was extended till 1969. But there's interesting story which is part of this 51 to 69. So when 1950 it was brought in, the review period for this act was 1 year. So it was from 1950 to 1st April 1951. Then, it became 1952. But in 1952, there was amendment brought in. So, which said that, it will be reviewed after 2 years. So remember, this Detention Act initially comes for 1 year, then amendment is brought in, and then the period of review, it will be paid before the parliament after 2 years. It continued for, till 1954, 52 to 54. And then 1954, it was again amended. And then the review process was made for 3 years. And then 54 to 57, and likewise it went on till 69. 57, 60, 63, 66, something like it went like this. So what was seen at that point of time, that it is an exceptional measure, a special act, and that was the promise which was given in the parliament, had become part of routine. It became part of political life of the country. You have other figures also. Say in 1950, there were around 10,962 people were detained. Fine, and then in 1951, numbers decreased to 2,116. Then next year it decreased to 1,116. Likewise, and so on and so forth. So ultimately, in 1957, it increased to 252, but fell to 177 in 1958. Now, so if numbers are going down, there's a whole question mark: why was it needed? But more than that, what was important was the threshold of review process, which is a very important part of any constitutional democracy, parliamentary democracy, where parliament looks into the act, reviews the act, amends the act, and sometimes repeals the act. But that review part is absolutely important. For many other, remember, we all are aware that there are statutory bodies like various commissions, National Human Rights Commission, Scheduled Caste Commission, Scheduled Tribes Commission. Now, their reports are presented in the Parliament. Okay, so Parliament becomes a body which keeps an eye on all other agency. Likewise, this is one measure, a review measure, where Parliament keeps a close watch on how executive is working. So, this increase of year of review, 1 to 2 to 3, is not certainly not healthy for democracy, because the parliamentary check over executive is compromised. In USA, normally they call a sunset clause, that once special laws come into existence, then they have a life, and after that it automatically lapses. We do have review process where after 2 years, 3 years it is reviewed. Let's take up, so we've dealt with detention law. Let's come to TADA, Terrorism and Disruptive Activities Act. So we know it came in 84 as Special Courts Act, 85 as an Act, Terrorism Disruptive Activities Act, and then it was renewed. It was renewed for every 2 years. Okay, so after every 2 years, TADA was reviewed, and it was renewed, and it continued. So in 1993, when it was renewed for the last time, because now we know that 95 it lapsed. It had become so routine and part of ordinary political life that only 8 members of parliament, excluding the minister, were presenting were in the house when the bill was presented. Fine. So in the last review, there were only 8 members, if you leave out the minister, participated in discussion, and that lasted only for an hour and 10 minutes. Okay. So only 8 members of parliament participated in this. And remember this, there were a lot of question mark raised about this. When you go to the parliamentary proceedings, and I'll refer to those periods, there were many who voiced concern about misuse of TADA, but you could see that it had already become a routine. But with TADA it was 2 years. Okay, so as a part of Act, after 2 years it was supposed to be reviewed by Parliament. When in 2001, Prevention of Terrorism Ordinance was brought in. Okay, remember 2001, the Twin Tower attack in USA, and 2001 December, 13 December attack on Indian Parliament, one of the the most serious attack on Indian democracy when Indian Parliament was attacked. Now, it's in this context that you have ordinance which is brought in. Ordinance actually put the period to 5 years. That this ordinance we know has a life. It has to go to the Parliament. And with 6 months, if it's not approved, then it would lapse. But it was a ordinance which said this law would work for 5 years, and then there was whole criticism. It was brought in and the whole criticism. So again, it was promulgated in December 2002, and as a result of criticism, a lot of criticism to this, an enhancement of the period. The period was reduced to 3 years, right? Now, interestingly, see the pattern. PDA Act 1 year, then 2 years, then 3 years. TADA 2 years. POTO starts with 5 years, then it goes to 3 years. But cumulatively, what you'll find, overall picture is a special law will be reviewed after 3 years, fine? So this whole debate about 2 years, 1 year, 3 years, but now it's 3 years. I'll come to, interestingly, we are still talking about TADA and POTA, substantive anti-terror laws, which was subject to review of the Parliament, and there was a period mentioned over there. The important thing which we all have to remember, that Unlawful Activities Prevention Act is a permanent act. There's no review over there. So what comes as special, right? What comes as extraordinary has now been routinized. I use the term, permanence of the temporary. But let's see the logic. What is the logic? So what is the logic behind this? The extraordinariness of the anti-terror laws. So all such laws, when TADA came in, POTA came in, when Unlawful Activities Prevention Act was amended, and I'm still talking about the national laws, okay? These laws come with an object, an intent, proclaiming the need to respond to specific problems of extraordinary nature. Like we're living in pandemic. It's extraordinary time. Remember what happened? This happened 100 years back. Okay, so these are not regular thing which happens. They are disease. They are viruses. They have different phases. But this kind of pandemic is extraordinary. So likewise, when extraordinary situation arises, fine, something which ordinary law cannot take care of. Ordinary situation it's not ordinary situation. So all such laws actually refer to special time, extraordinary times, extraordinary, and they say, well, such measures are needed to counter such extraordinary situation. And in this case, extraordinary crime called terrorism. So if you see this logic, then what follows from this fact of extraordinariness is that these laws are temporary and their lives are supposed to be coterminous with the extraordinary event they intend to overturn. Now, just think over it, because extraordinary times, I mean, we know since last year we're facing pandemic, fine. We are going through a very bad phase of pandemic, fine. But we all know it will not last for, long time, fine. Okay. Now, likewise, so any measure which is brought to tackle this, emergency measures, are coterminous with extraordinary situation. Hence, they are supposed to be temporary in nature. Now, having said that, we'll examine, has this happened? Those temporary measures which were brought in to tackle extraordinary situation, have they, given way to ordinary law of the land, or do they continue? Now, we using the term of extraordinary law or extraordinary measures. So, what are these extraordinary measures? Fine, and what are the extraordinary provisions of such laws? So, laws like TADA, POTA, and Unlawful Acts Prevention Act, they have special provisions pertaining to arrest, detention, bail, investigation, evidence, trial, and punishment. I'll take up only one, of the provision, and that's my focus would be to examine how has that provision worked. What does law say? What are safeguards within law, and how have courts responded to that? So before I move to that, let me tell you very clearly, and that's very important, that these extraordinary laws have certain provisions which are special provisions, which very clearly say that these are not ordinary times. We need to have something stringent. Now, having said that, remember the safeguards which are inbuilt into some of these laws, the procedural safeguards, are absolutely important. We cannot just do away with that. Fine. So if communication like telephone, mobile phones, computers, other form of communication are intercepted, under POTA, there were safeguards that you needed permission, you have to inform, etc., etc. Now, if those procedures are compromised, then whatever safety which accused have is gone. Okay, so procedures are absolutely important over here. That we have to keep in mind. Now, among them, one of the which probably everyone knows around, all esteemed members who are part of faculty development program are probably aware. There's something called principle which is part of criminal justice system in India, called you are innocent until you're proven guilty. So you may be arrested, but you're not a criminal. Right? You are an accused. You may be in judicial custody, as the formal term is, prisons. You may be, so when you're part of judicial custody, you're sent to prison. So you may be judicial custody, but this does not mean that you're criminal, because you're basically under trial. A convict is one who's been convicted of a crime. Fine, it's been proven that the person has committed a crime. Hence, the person becomes a convict. Okay, he's been convicted. Prior to that, person remains innocent till the time proven guilty. And when it comes to criminal act, state is the agency, police is the agency which collects evidence, which investigates, and which prosecutes. Okay, so state collects evidence. In TADA, in POTA, remember, so in anti-terror law, the burden of proof is reversed. It's there in some other laws also, but I won't go into this. Say, for example, at the site of a blast, if there's any evidence, your fingerprints, okay, your cloth, some other element, then you will have to prove that you are innocent. Fine. Uh, so burden of proof would be reversed. So, these are technical. It seems many of the colleagues would be okay. But it's just coming in newspapers, right? You may have read about all these things, so it's perfectly legitimate that we discuss this. Also, remember the purpose of such laws is very clear. They are draconian in nature, and this is not a criticism. It is, and these are the laws which are supposed to be very strong, very stringent in order to deter acts of terror, right? So you make it so strong, fine, so effective, so that nobody dares to challenge, fine, and commits heinous crime like terrorism. So these are draconian, extraordinary provisions. Another feature is in criminal justice system, then what you will have is an ordinary parallel criminal justice system where you'll have magistrate, you'll have police, you have IO, investigating officer, you'll have public prosecutor, you'll have courts, and then you have appeal courts. Say from lower court, you can go to high court, you can go to the Supreme Court. Anti-terror laws work with a framework where you will have an entire parallel criminal justice system working. So a police person of a certain rank, say deputy superintendent of police, only they can record evidence in the form of confession. Then trials that take place in the term was designated court under TADA and special courts under POTA. So you have special courts. NIA, National Investigation Agency, also has special court, right? CBI is also special court, but we're not talking about CBI. We're talking about anti-terror laws, TADA, POTA, and NIA. So they'll have a special court as such. Punishment, would be of enhanced punishment, right? So you'll have a whole parallel system operating over here. So these are broad, features of law. So if someone asks, why do we call these laws extraordinary? Then answer would be, these are extraordinary because they're extraordinary provisions, fine. Answer would also be that these are extraordinary laws because they intend to overturn, reverse extraordinary situation into a normal situation, fine. This we have to keep in mind. And when we talk of laws like TADA, POTA, UPA, we also talk of regime of a law, because regime of law is not about just bare provision. We're not talking about just rules, regulations, etc. Because we all know that laws come in a certain context where the political forces, social forces are operating. So so when we use the term three regimes of anti-terror law, TADA, POTA, and UAPA, we are also talking about the political and ideological embeddedness and the discursive practices which accumulate around such law. So TADA came in the context of disturbances in Punjab, act of terror in Punjab, demand for Khalistan, external power getting involved over here, right? And there was a situation where even emergency was invoked, fine. And then after regular political process was not taking place. In Jammu Kashmir, you do have a certain situation, fine. So there's whole political and ideological embeddedness around and such phenomena. So we are not just talking about provisions as such. We're talking also about the context in which such things happening. Now, in all three regimes, what you'll find is there's something distinctive, but also there's something which continues. So there's a whole relay thing which carries on with that. Having said that, let me just probe at least whatever time we're left with at least one extraordinary provision, and that is confession before a police officer. And I'll discuss this in some detail. What do we mean by confession before police officer? Why is it important when we discuss anti-terror laws and its implication for individual rights? wider democracy and rule of law. So Section 15 of TADA has a provision which deals with confession by accused and co-accused. And those who have not seen, here is a copy of Bare Act called TADA. POTA, Section 32 of POTA had a provision on confession of accused before a police officer. Interestingly, and this is Unlawful Acts Prevention Act. This is 1967 copy, and this is latest 2018 copy. So in UAPA, interestingly, the confession clause is not there. In the sense, it was removed, and that's the story which we're talking about, right? That now it's not part of Unlawful Acts Prevention Act. It was part of TADA and POTA. So confession before police, is it completely has been done away with, and it's no longer part of our legal framework? Probably it's in time to bring in state level legislation. No, it is still there. Confession is still there. It's not part of UAP. It's not part of that central legislation, but it's part of MACOCA. Fine. Law against organized crime. Maharashtra brought this law, but this law was invoked in many other places, including Delhi. Then Chhattisgarh Special Public Safety Act, operating in Chhattisgarh. More recently, Gujarat Control of Terrorism and Organized Crime Act. So many would say, well, we don't see terror activities taking place over there. But Gujarat was persistent. It thrice passed a law dealing with organized crime and combating terrorism in its assembly. Finally, on 15th October 2019, when it again 4 times passed, then President gave the assent to this act. So it is called Gujarat Control of Terrorism and Organized Crime Act 2015, but it received President's assent, signature on 15th October 2019. So in the central act, it's not there, but at the state level act, confession provision is there. I'll spend some time on this. So we need to ask, what is the constitutional provision, and how does Indian Evidence Act 1872 deal with confession, and what did Supreme Court say about confession, both in Kartar Singh versus State of Punjab case 1994, and later in Parliament Attack case, when Parliament Attack case was reviewed in 2005. So we go to this. The most important section which we must keep in mind, there is a constitutional right against self-incrimination. And let me read this section from the Constitution itself, the Constitution of India, which talks about Article 20, Clause 3 of the Constitution of India declares that no person accused of any offense shall be compelled to be a witness against himself, embodying thereby the principle of protection against compulsion of self-incrimination. Remember, this is a fundamental right. This is there in the Constitution, that you cannot force a person to become a witness against himself. Okay, this is a very important safeguard in jurisprudence all over the world, right? So this is, having said that, what does ordinary law say? So ordinary law regarding evidence, the Indian Evidence Act, there are 2 sections, 26 and 27 of the Indian Evidence Act 1872, which says no confession made by any person while he is in the custody of a police officer, unless it be made in the immediate presence of a magistrate, shall be proved as against such person. So if we are making confession, an accused is making confession, it has to be done in the presence of magistrate, right? And nowhere else. Then it says, provided that when any fact is deposed to as discovered in consequence of information received from a person accused of any offense in the custody of a police officer, so much of such information, whether it amounts to a confession or not, as relates directly to the fact thereby discovered, may be proved. So what does this mean? It means that's, suppose a person's been arrested. He makes certain statement before police, and that's police job to, ask questions and record the statement made by the person. Now, if based upon certain, statement made by that person, you are able to, find out the weapon which was used, or jewelry which was stolen. Fine. This part would be valid. So if statement made before the police and discovery has taken place, then it's valid. That won't be there. But in no other case will that statement will be used. The person has to make statement before the magistrate. Only that statement would be valid. Now this is a wisdom. Remember, many actually once something happens, crime happens, dacoity happens, murder happens, and terror act happens, we immediately, call for, punishment. Trust me, India has kept, the flag of rule of law and democracy flying very high. Fine. Among all civilized countries, India is probably among the top, one of the top countries over there. So when there was open brazen attack on in Mumbai, on the streets of Mumbai, and when one of the person was arrested and convicted, Kasab, we went through entire trial process. We followed the entire rule of law as such, and that's what makes us proud. Other part which we must remember is that, in nearly all cases, if a terror accused is produced, there'll be some of one or the other law which defends. I know there's been trend that in certain bar councils pass resolution that we won't defend this person. No, in India, everyone gets a right to lawyer, and they get a fair hearing in the court of law. That's what we have to uphold. Now, what is there any problem with confession? Fine. We know that's right. Protection against self-incrimination is a fundamental. Fine. So confession is seen as suspect unless it is unquestionably established, state and trial takes place, has all the safeguards, and those safeguards have been adhered to. Okay. What did TADA do? Section 15 of the TADA laid down that notwithstanding anything in the code, remember we just read Criminal Procedure Code, and the sections 26 and 27 of Indian Evidence Act. We just read that, right? We heard that. Okay, so it says that notwithstanding anything in the code, that is Evidence Act, but subject to the provisions of this section, a confession made by a person before a police officer not lower in rank than superintendent of police and recorded by such police officer either in writing or on any mechanical device like cassettes, tapes, or soundtracks, from out of which sounds or images can be produced, shall be admissible in the trial of such person for an offence under this act or rules made thereunder. So it very clearly says that whatever is there in Evidence Act won't matter when it comes to TADA, and a police officer not lower than a rank of superintendent police, so SP and higher up, may record confession both either in cassette, tape, soundtrack, writing as such, fine, and this will be admissible in the court of law against that person. Now, the person, as per TADA, is not bound to make a confession, right? He may not actually say against himself before the police because this evidence will be used against him. So it will be only recorded if the confession is being made voluntarily. So remember, status of confession is very high in entire jurisprudence. It's something very high, and you have complete remorse when you believe that your heart says that there's something wrong, and you must face that punishment. Only then you do that. Okay. In Supreme Court in Kartar Singh versus State of Punjab, what it did, it affirmed the admissibility of confessions as it accepted under TADA. Fine, it accepted that what is in TADA, it's accepted. So it was accepted, it was seen as legal. Fine. If confession has been taken, then those guidelines have to be affirmed. And the guidelines were that confession must be recorded in a free atmosphere in the same language in which the person is examined and as narrated by him. So if you're speaking Hindi or Tamil or Bengali or whatever, if you're speaking that language, or for example, Punjabi or Kashmiri, whatever, then it has to be recorded in that language. Okay, and whatever is narrated, that has to go there. And the person from whom a confession has been recorded, once you record the confession, then the person will have to be produced before Chief Metropolitan Magistrate or Chief Judicial Magistrate. To that person, to that magistrate, the confession will have to be sent. So police record the confession, then they send the confession, the original statement of confession, written or recorded, to the either Chief Judicial Magistrate or Chief Metropolitan Magistrate, depending on the kind of jurisdiction which one is talking about. And Chief Metropolitan Magistrate or Chief Judicial Magistrate must scrupulously record the statement. Fine, they must very scrupulously, they should go through the statement, fine, which has been produced, made by the accused and produced, and get his signature. And in case of any complaint of torture, he may ask the medical officer, not less than rank of assistant civil surgeon, to look into the case. And then there's a whole thing about this is the part. The fact is, large number of convictions took place only on the basis of confession. Gradually, courts opened up and they said, you need other evidences together. Now, the confession issue came up, though it came up very late. Tata left warden parliament attack, was shot dead. In the presence of parliament, was whole trial, special courts have responded. Parliament has responded. Now, this is what Supreme Court has to say, a review of the Parliament attack case. So, Supreme Court, and this is part of POTA, Section 32 of POTA, a two-judge bench, they are the one who were deliberating on this. And the judges, what they had to say was, and I'm quoting a judgment, it is perhaps too late in the day to seek reconsideration of the view taken by the majority of judges in the Constitution bench. But as we see Section 32 of POTA, a formidable doubt lingers in our minds, despite the pronouncement in Kartar Singh's case. So they're referring to Kartar Singh case 1994, where the Supreme Court accepted confession as a part of confession before police. Remember, statement before police are accepted, but statement before magistrate is accepted. Statement, whatever your statement you make before magistrate, that has legal sanctity. But here, police recorded confession, and it was accepted in the court of law under Tada and Pota. So they are referring to that. So they're saying that doubt lingers in our mind despite pronouncement of this bench in Kartar Singh course. Within court, many questions do arise, and we are unable to find satisfactory or even plausible answers to them. If a person volunteers to make a confession, why should he be not produced before a judicial magistrate at the earliest and have the confession recorded by a magistrate? So the person is in police custody, fine. They have, got hold of this person, arrested a person. So judges, Supreme Court judges say, if they are in police custody, why can't they take the person to judicial magistrate at the earliest and have the confession recorded by the magistrate? The magistrate could be reached within the same time within which the empowered police officer could be approached. So remember, it's not just like, SHO and sub-inspector, and then any other policeman we're talking about. Even under the law, Tada and Pota, confession could be recorded by police officer of a certain rank, so higher police officer. So court is saying, in any case, it will take time to find those police officer, and same time you can take to reach out to magistrate. The doubt becomes even more puzzling when we notice that in practical terms, a greater degree of credibility is attached to a confession before a judicial officer. See, that is accepted. Once you make a statement before judicial officer, that has credibility. People accept that because the criticism is that police uses third degree method, torture, fine, and as a result, out of fear, fine, people accept certain things, accept certain things, whereas there's no such fear before the judicial officer, so it has higher credibility. Then judges say, then why should not the investigating officer adopt the straightforward course of having to resort to ordinary and age-old law? If there is any specific advantage of conferring power on a police officer to record the confession receivable in evidence, if the indictment and indentment and desideratum of the provision indisputably remains to ensure an atmosphere free from threats and psychological pressures, why this circuitous provision of having confession recorded by the police or of the rank of SP? So this saying, when it is there accepted, when Supreme Court in Kartar Singh said that confession has to be recorded in an atmosphere free from threats, fine, free from psychological pressure, then why we have this circuitous provision of confession recorded by the police officer? Because there's no better place where atmosphere is free and there's hardly a threat of psychological pressure except for the court of law. Fine. Courts say even if the police officer, certain rank or superintendent of police, even if he be the immediate superior to the IO who oversees the investigation, and then requiring the production of the accused before the chief magistrate, metropolitan or judicial magistrate within 48 hours. So why to follow all this? Straight, you have got hold of the person, you have interrogated the person is willing to make confession, take it to the judicial magistrate or metropolitan magistrate, let them record, and then they have a very strong word to say. They say that evils which the framers of the Indian Evidence Act has in mind to exclude confessions to the police are still prevalent, though not of the same degree. So remember 1872, when Indian Evidence Act comes in the context of, remember, Madras Presidency Famine, code which was there, and there was torture of people who were producing by those who were taking rent. In that context, there was evidence given that police shouldn't be this job because they use third degree method or torture and things like this. Torture Commission report. Now, based upon that, Indian Evidence Act was prepared in such a manner that police would not have all the power. Statement before magistrate would be accepted, So they're referring to that as saying that, the situation which was there, it's not completely over. Even many among the public tacitly endorse the use of violence by police against the criminals. Judges are aware that, large number of public probably would say, okay, give me the result. Use, and not only public, especially the affluent sections, people in power, they pressurize police to act in this manner. In this scenario, we have a serious doubts whether it would be safe to concede the power of recording confessions to the police officers to be used in evidence against the accused, making the confession and the co-accused. In Tada, remember, thing was confession of the accused, but suppose you say you're innocent, but someone who's part of that case, who's co-accused, he or she says that no, this person was involved. Even if you keep on pleading that I was not involved, based upon co-accused, will be punished. In POTA, this co-accused provision was gone. In UAPA, it's completely, eliminated. So it's not that the same law is there. Laws have changed. UAPA is different in that sense that, it does not have that draconian provision which was part of POTA and TATA. UAPA has another provision, features that we won't take up. There's not time, not sufficient time to go into detail. So these provisions are important. Having all these draconian provisions, you have some data about working of TATA and later for POTA. So, at least Hindu newspaper, it reported a statement by Rajesh Pilot that over 67,000 were detained under TATA, right? Around 8,000 were tried, very few were convicted, and large number of them, around over 50,000, who were there in the prisons, who were detained, but no case could be brought against them. So the conviction rate was very low. Okay. Even in spite of all such provisions, special provisions, the review committee of TATA stated that other than 5,000 cases, the application of TATA was wrong. So, you have large numbers who were, so, what is, the problem is what happens once you have all these special, provisions, then it becomes easy for investigative agency to apply such laws, fine? So, very few people would probably be aware that the highest number of TATA cases came from Gujarat. And remember, you're talking about 90s, a large number of trade union members were imprisoned under that, right? So I don't think I have time to really go into UAPA in detail. But I need to. I mean, there are other laws which are there again, Makoka, and remember, irrespective of parties in power. So TATA was opposed by BJP, fine, brought by Congress, opposed by BJP. Then POTA was brought by NDA, led by BJP, opposed by UPA, led by Congress, right? Interestingly, when UAPA, Unlawful Activist Prevention Act, was amended, fine, 2008, then all parties came together, and since then there is a common, they all have agreed to amendments over there, but the provision of confession initially came in Makoka, right? It was opposed by Congress in Parliament debate as such, but when it was brought in, it was Congress which was in power in Maharashtra. So, irrespective of parties, there's a whole political regime, social forces which continue to work. In Jharkhand, it is criminal law amendment which works. Chhattisgarh, there's Chhattisgarh Special Act which is there. Gujarat, now they have a new act. Question which we ask: have they remained exception or have they become norm? As far as the fact is concerned that earlier you had review provision, TATA 2 years, and then POTA 3 years, and they were under scrutiny by Parliament. Now it's no longer there. It's no longer exception. Extraordinary laws have become norm. They are no longer extraordinary. They are stringent draconian law, but they are norm. Unlawful Activist Prevention Act is a permanent law which is there on this statute book. So I'm leaving you with certain food of thought. You can think about it. There are certain questions over here. And this I'm referring to a speech by L.K. Advani. Remember, L.K. Advani is the one who brought in Pota. He brought, as he was home minister, so that was his task. But speaking on Tata on 24th August 1994, Advani had to say following things. Sir, Tata is not a sir. He's referring to, obviously referring to speaker. Tata is not an ordinary law. It is contrary to the spirit of democracy. When Tata bill was introduced here, several members had opposed it. Most of the members that apprehended that whenever such privileges are given to the executive or the police, they are generally misused. Let me emphasize, whenever such privilege is given to the executive or the police, they are generally misused. However, an assurance was given at that time that terrorism is a peculiar and extraordinary problem, and there's a need of a law like TADA to combat this problem. It was only then that the bill was passed by the House. Since then, the law has been misused so flagrantly that the Honourable Minister had to urge the state government to check the misuse of TADA, the Home Minister. So you have Advani speaking that is contrary to the spirit of democracy. When you give power to the executive or the police, there will be tendency to misuse. And this is what happened. It was misused. That's what El Kadwani, a senior statesman and leader of BJP, spoke in 1994. On the other hand, from the left, Somnath Chatterjee, in the same speech, he said, "It is better that the police people do not forget the ordinary method of investigation, ordinary method of trial. This is what is happening. The police are forgetting, and the mischief was started with the MISA." So he's saying that it started with MISA, fine, during emergency. And now that was a detention law. Now you have TADA, which is being misused. I'm leaving you with this following statement of Mahatma Gandhi. You don't have to agree with this deliberation. There are grounds for complete justification of special laws. Those who question, they question its misuse. And there are certain people who would question the very fact that these laws are bad laws because they are always open to misuse, fine, because they give power to executive. And this is what Mahatma Gandhi had to say. And the title of his speech was What to Do. It was published in Young India on 16th August 2019. And he says, an executive that asks for extraordinary powers is as a rule to be distrusted. Extraordinary powers are asked by those who wish to cover their inefficiency or inability to cope with an evil. So if you're prepared for things to come, you'll be able to cope with that, manage them better. Let me repeat what Mahatma Gandhi said. An executive that asks for extraordinary powers is as a rule to be distrusted. Extraordinary powers are asked by those who wish to cover their inefficiency or inability to cope with an evil. This was the context of the Anarchical and Revolutionary Crimes Act, or as it's properly known as Rawlett Act 1990. I leave you with this statement from Mahatma Gandhi, fine, and I wish you best, fine, during pandemic. I wish you that you remain yourself safe and you keep yourself healthy and take care of yourself. So best wishes, and collectively will pass this, take this challenge and go beyond pandemic. Thank you so much, all of you. Thank you.